Good morning. I welcome everyone to this confirmation hearing on the nomination of Judge Brett Kavanaugh.
Mr. Chairman.
To serve as Associate Justice.
Mr. Chairman, I'd like to be
Supreme Court
recognized for a question before we proceed.
Regular order, Chairman.
Mr. Chairman, I'd like to be recognized to ask a question before we proceed. The committee received just last night, less than 15 hours ago, 42,000 pages of documents that we have not had an opportunity to review or read or analyze.
You're out of order. I'll proceed.
We cannot possibly move forward, Mr. Chairman,
I
with this
extend
hearing.
a very warm welcome
We have not
to
been
Judge
given
Kavanaugh,
an opportunity to have a meaningful
his wife,
hearing on
Ashley,
this nominee.
their two daughters,
Mr. Chairman,
their
I
extended
agree with my
family and
colleague,
friends,
Senator Harris. Mr. Chairman,
Judge
we
Kavanaugh's
received
many law
42,000
clerks,
documents that we haven't
and
been able
everyone else
to
joining us
review last
today.
night, and we believe this hearing
I
should be
know this is an
postponed.
exciting day for all of you here, and you're rightly proud
Mr. Chairman,
of
if we cannot be recognized, I move to adjourn.
the American people.
Mr. Chairman, I move
get
to adjourn.
Hear directly from Judge Kavanaugh later this afternoon.
Mr. Chairman, I move to adjourn. Mr. Chairman, we have been denied real access to the documents we need to advise.
Mr. Chairman, regular order is called for.
Which turns this hearing into a charade and a mockery of our norms.
Well,
and Mr. Chairman, I therefore move to adjourn this hearing.
Okay.
This is a mockery and a travesty of justice. This is a travesty of justice. We will not go back. Cancel Brett Kavanaugh. Adjourn the hearing.
Command order. Chuck. There's a motion to adjourn, but
We're not in executive session.
Mr. Chairman, I ask for a roll call vote on my motion to adjourn.
Okay.
Mr. Chairman, I move to adjourn. I ask for a roll call vote.
We're not in executive session. We will continue as planned.
Mr. Chairman, may I be recognized, sir? Mr. Chairman, I appeal to the chair to recognize myself or one of my colleagues.
You're out of order.
Mr. Chairman, I appeal to be recognized on your sense of decency and integrity. Even the documents you have requested, Mr. Chairman, even the ones that you said, the limited documents you have requested, this committee has not received. And the documents we have, you, sir, have labeled committee confidential. They should be transparent. This committee, sir, is a violation of even the values I've heard you talk about time and time again, the ideals that we should have. What is the rush? What are we trying to hide by not having the documents out front? What is with the rush? What are we hiding by not letting those documents come out? Sir, this committee is a violation of the values that we as a committee have striven for, transparency. We are rushing through this process in a way that is unnecessary. And I appeal for the motion to at least be voted on.
Mr. Chairman.
At least let's have a vote, because when we wrote you a letter on August 24th asking to have a meeting on this issue, you denied us even the right to meet. So here we are having a meeting. Let's at least debate this issue. Let's at least call this for a vote. I appeal to your sense of fairness and decency, your commitments that you've made to transparency. This violates what you have even said and called for, sir. You've called for documents, you yourself, limited documents. We thought there should be more. We have not received the documents that you have even called for. So, sir, based upon your own principles, your own values, I call for at least to have a debate or a vote on these issues and not for us to rush through this process.
Mr.
Chairman.
Senator,
Mr. Chairman, I've
Senator,
heard calls for
I'd like to
regular
respond.
order.
I'd like to respond to Senator Booker. Senator Booker, I think that I respect very much a lot of things you do, but you spoke about my decency and you spoke about my decency and integrity, and I think are taking advantage of my decency and integrity. So, okay.
The order, it is regular order for us to receive all the documents, that this committee is entitled to.
Okay.
Mr. Chairman, it is also,
I think that
Mr. Chairman, it is also not regular
Hey,
order for the majority
Senator
to
Rono.
require the minority to pre-clear
Sen-
our questions, our documents, and the videos we would like to use at this hearing. That is unprecedented. That is not regular order. Since when do we have to submit the questions and the process that we wish to follow to question this nominee? So I'd
Senator,
like your clarification. I'd like your
Senator
response
Rono,
on why you are
I
requesting
would
the
ask
minority
that
to
you,
submit our questions to
I
you.
ask that you stop so we can conduct this hearing the way we have planned it. Maybe it isn't going exactly the way that the minority would like to have it go, but we have said for a long period of time that we were going to proceed on this very day, and I think we ought to give the American people the opportunity to hear whether Judge Kavanaugh should be on the Supreme Court or not. And you have heard my side of the aisle call for regular order, and I think we ought to proceed in regular order. There will be plenty of opportunities to respond to the questions that the minority is legitimately raising, and we will proceed accordingly.
Mr. Chairman, under regular order, may I ask a point of order, which is that we are now presented with a situation in which somebody has decided that there are 100,000 documents protected by executive privilege, yet there has not been an assertion of executive privilege before the committee. How are we to determine whether executive privilege has been properly asserted if this hearing goes by without the committee ever considering that question? Why is it not in regular order for us to determine before the hearing at which the documents would be necessary whether or not the assertion of privilege that prevents us from getting those documents is legitimate or indeed is even an actual assertion of executive privilege? I do not understand why that is not a legitimate point of order at this point, because at the end of this hearing, it is too late to consider it.
Mr. Chairman, if I might add to this, on the integrity of the documents we've received, there really is no integrity. They have alterations, they have oddities, attachments are missing, emails are cut off halfway through a chain, recipients' names are missing. Many are of interest to this committee, but it's cut off. The National Archives hasn't had a chance to get us all that we want, even though you sit on your website. The National Archives would act as a check against any political interference. But I check after the hearing is over is no check. I think we ought to at least have the National Archive finish it, and to have, for the first time, certainly in my 44 years here, to have somebody say there's a claim of executive privilege when the president hasn't made such a claim just puts everything under doubt. What are we trying to hide? Why are we rushing?
I can answer all the questions that have been raised, but I think if I answer those questions, it's going to fit into the effort of the minority to continue to obstruct, and I don't think that that's fair to our judge. It's not fair to our constitutional process. But let me respond to those now, and then maybe we can proceed. My colleagues on the other side are accusing the administration of using executive privilege to hide documents from the committee. I want to say why they're wrong. Unlike President Obama's assertion of executive privilege during Fast and Furious is one example, this assertion is not legitimate. Judge Kavanaugh was a senior lawyer in the White House. He advised the president on judicial nominations, provided legal advice on separation of powers issues, and handled litigation matters. As the Supreme Court has put it, quote, unless the president can give his advisors some assurance of confidentiality, a president could not expect to receive the full and frank submissions of facts and opinions upon which the effective discharge of his duties depends, end of quote. The issues Judge Kavanaugh worked on are exactly the sort of issues that require, according to the Supreme Court, some assurance of confidentiality. We in the Senate and everyone else in America expect exactly the same sort of confidentiality. Most senators would not agree to turn over their staff's communication to anyone. For example, we didn't ask that Judge Kagan's records for her service with then Senator Biden be turned over during her nomination. And because of attorney-client privilege, everybody has a right to keep communications from their lawyers out of government hands. We therefore didn't ask for Justice Ginsburg's documents from her time with the ACLU. We didn't ask for Judge Sotomayor's confidential documents from her time in private practice. It can't be that the Senate and the ACLU are entitled to more protection than the President of the United States. And then I will speak to the fact about 42,000 pages. Last night, we received additional documents for the committee's review. These were documents we requested before the hearing, and we received them before the hearing just as we requested. The majority staff began reviewing the documents as soon as they arrived and has already completed its review. There is thus absolutely no reason, that's no reason to delay the hearing. We have received and read every page of Judge Kavanaugh's extensive public record. This includes 12 years of his judicial service on the most important federal circuit court in the country, where he authored 307 opinions and joined hundreds more, amounting to more than 10,000 pages of judicial writing. We also received and read more than 17,000 pages of his speeches, articles, teaching materials, other documents that Judge Kavanaugh submitted with his questionnaire, the most robust questionnaire this committee has ever issued. And of course, we received and read more than 483,000 pages of documents from Judge Kavanaugh's extensive executive branch service. This is more pages than the last 5 Supreme Court nominees combined. In short, this committee has more materials for Judge Kavanaugh's nomination than we have had on any Supreme Court nominee in history. Senators have had more than enough time and materials to adequately assess Judge Kavanaugh's qualifications, and so that's why I proceed. I know that this is an exciting day for all of you in the family and all the people that are close to Judge Kavanaugh, and you're rightly proud of the judge. The American people get to hear directly from Judge Kavanaugh later this afternoon. After this confirmation hearing and process is finished, I expect Judge Kavanaugh will become the next Associate Justice of the Supreme Court. Welcome again, Judge. Before I begin, I would want to give you, Judge, an opportunity to introduce your family.
Thank you, Mr. Chairman and Senator Feinstein. And
Push the red button if it's not on.
Will we have opening remarks?
Yes, we're going to have. Yeah.
Thank you, Mr. Chairman and Senator Feinstein and members of the committee. I'm honored to be here today with my family, my wife, Ashley, proud West Texan, graduate of Abilene Cooper High School, now the town manager of our local community where we live. Our daughters, Margaret and Liza. Thank the committee for arranging a day off from school today. My mom and dad, Martha and Ed Kavanaugh, my aunt and uncle, Nancy and Mark Murphy, and my first cousins, Rosie and Elizabeth Murphy. I'm very honored to be here, honored to have my family here. I'm here because of them. Thank you, Mr. Chairman.
We're delighted to have your family here. Before I make my opening remarks, I want to set out the ground rules for the hearing. I want everyone to be able to watch the hearing without obstruction. If people stand up and block the view of those behind them or speak out of turn, it's not fair or considerate to others, so officers will immediately remove those individuals, and I thank the officers for doing the work that they have to do. We'll have 10-minute rounds of opening statements with each member. The ranking member and I may go a little over 10 minutes, but I'm going to ask everyone else to limit your remarks to those 10 minutes. I hope everyone will respect that. We plan on taking a 15-minute break after Senator Cruz's opening statement. After all the opening statements by senators are complete, we'll take another 15-minute round break to turn to our introducers, who will formally present the judge. After that, I'll administer the oath to the judge, and we'll close that portion of today's hearing with his testimony. Tomorrow morning.
Mr. Chairman, when will we review Senator Blumenthal's motion to adjourn?
What's your question?
I renew my motion to adjourn, Mr. Chairman. I think we're entitled to a vote on it.
Yeah.
The responses that, Mr. Chairman, you've given with all due respect really fly in the face of the norms of this committee, our traditions, and our rules.
Mr. Chairman, if I might add an additional point, I agree with my colleague. It is striking, given your long history of encouraging the executive branch to treat minority requests equal with majority requests, that you discouraged the National Archives from responding to Ranking Member Feinstein's request, which she tried to craft with you to be identical to the request for records from Justice Kagan. We should not be proceeding until we have the full documents that allow us to review the judge's records.
And Mr. Chairman, last Friday we learned that nearly 102,000 pages of documents from Judge Kavanaugh's work in the White House counsel's office are being withheld from the committee and the public based on a claim of constitutional privilege. Executive privilege has never been invoked to block the release of presidential records to the Senate during a Supreme Court nomination. This includes when Justice Kagan was nominated to the Supreme Court, as well as Justice Roberts. Yesterday, my colleagues and I sent a letter to the White House counsel asking that the president withdraw his claim of privilege over these documents so that they can be made available to this committee and to the American people. We have not yet received a response to that letter, so we should not be proceeding until we have a response and these documents have been available. It is 102,000 documents.
And Mr. Chairman,
my motion to adjourn, Mr. Chairman, would raise this issue of executive privilege and whether it has been properly asserted for reasons that have been outlined well by my colleague, Senator Whitehouse. There is no valid claim here of executive privilege. Even if there were one, it has not been properly asserted. The question is, what is the administration afraid of showing the American people? What is it trying to hide?
And Mr. Chairman, using your own words in the statement you just read, you said, I quote, "We've had more than enough time to review the documents." Sir, we just got a document dump last night of over 40,000 pages. I would venture to say not one senator here has had time to read through those 40,000 pages. And so we are continuing to rush through this process, a process that deserves to be scrutinized. I support Senator Blumenthal's motion to adjourn, and I hope that we could at least have a vote on that motion.
Mr. Chairman, I think you'd be hard-pressed to find a court in the country that would not give a party litigant a continuance when the party on the other side did a 42,000-page document dump after close of business the night before trial.
Mr. Chairman, we waited for more than a year with a vacancy on the Supreme Court under the direction of your leader in the United States Senate, and the Republic survived. I think the treatment was shabby of Merrick Garland and President Obama's nominee. The fact that we cannot take a few days or weeks to have a complete review of Judge Kavanaugh's record is unfair to the American people. It's inconsistent with our responsibility under Article 2, Section 2 of the Constitution to advise and consent on Supreme Court nominees.
Senator Cornyn. You want to speak?
Mr. Chairman, thank you. I'll be very brief. I would just say that Senator Whitehouse has suggested that we handle this hearing like a court of law. But I would suggest that if this were a court of law, that virtually every side, every member of on the dais on that side would be held in contempt of court.
Oh, come on.
Because this whole process is supposed to be a civil one where people get to ask questions and we get to get answers. And that's the basis upon which we are to exercise our constitutional responsibilities of advice and consent. So I would just suggest we get on with the hearing.
If my colleagues...
Mr. Chairman, if I could just respond. Mr. Chairman, if I could just respond.
Mr. Chairman.
If we could just respond to that.
I would...
Sir.
You can respond, but just a minute. If people wonder why the chair is so patient during this whole process, I have found that it takes longer to argue why you shouldn't do anything than let people argue why they want it. These things are going to be said throughout this hearing. We're going to be in session Tuesday, Wednesday, Thursday, Friday, Saturday, Sunday, till we get done this week. So however long people want to take, we're going to not necessarily accommodate all obstruction, but if people got something to say, this chairman's going to let them say it. But it gets pretty boring to hear the same thing all the time. Senator Booker, make it quick, please.
I really appreciate the deference, Mr. Chairman. The question was, why would we want to delay this? And this is not an attempt to delay. This is an attempt to be fully equipped to do our constitutional duty, which everybody, Republicans and Democrats on this committee, take seriously. It is very hard to perform our role of advice and consent when we do not have a thorough vetting of the background of the candidate in areas which the candidate himself has referred to as the most formative part of his legal career, where he himself has talked about how important this period of his life is. We're denied the full vetting. And sir, this is not something that Democrats are asking for. I remind you that you yourself asked for a limited set of documents for when he was in the White House counsel's office. You yourself set that standard. And even on that limited standard, sir, we have not received the documents. And then even the documents, we've received 7% of them. Almost half of those have been labeled committee confidential that cannot be put before the American people, which further undermine and inhibit our ability to ask questions to thoroughly vet this candidate and advise and consent the President of the United States. So, sir, just on the basic ideals of fairness, the traditions of this body, we should have a thorough understanding of the nominee that's put before us so that we can vet them. To go into this hearing without those documents is an undermining of the constitutional role to which we have all sworn an oath to uphold.
Mr. Chairman, I have great respect for my colleague from Texas.
I would like to respond to Senator Booker, and then Senator Feinstein has asked for the floor.
Mr. Chairman, I asked to respond to my colleague from Texas. Mr. Chairman.
Senator Booker, using a standard set by 2 members of your political party in the caucus, and I'm going to phrase because I don't have the exact quotes in front of me, but recently Senator Schumer said from the floor, the best judge of whether or not somebody should be on the Supreme Court is decisions that they've made at lower courts. Senator Leahy said something similar to that when Senator Sotomayor was before us, that we know what you have done in a lower court. That's the best basis for knowing whether or not you ought to be on the Supreme Court. So we have 307 cases that this nominee has written decisions on as a basis for that. And we've got 488,000 other pages, and maybe the senators haven't read them, but their staff is fully informed, because last night before 11 o'clock on the 42,000 pages that have come to our attention, the staff on the Republican side has gone through them.
But, sir, then why did you ask for the White House counsel documents? They were not germane to this hearing. Why would you even ask for them?
Senator Feinstein.
For the record, that's a rate of 7,000 pages per hour. That's
Right.
superhuman.
Yeah.
They're amazing. They're amazing.
Mr. Chairman,
Yes,
if
go
I
ahead.
may,
Yeah, proceed.
I've been through 9 Supreme Court hearings.
Is this your
and
opening statement?
It's part of it.
Why don't you make your opening statement?
Shall I?
Yeah, would you please? And then-
Mr. Chairman, I asked for an
motion
opportunity to
pending.
respond to my colleague from Texas because he is directly challenged us with...
I said you're out of order.
Well, Mr.
Senator
Chairman,
Feinstein.
I ask in the process
Would
of
you-
regular order
Would
an
you-
opportunity to respond to what I
let
believe
me-
was a personal attack.
I'd like to have you give Senator Feinstein the courtesy of listening to her opening statement.
Well, I was just going to say some things. And you heard that this is my 9th hearing. And I think we've got to look at this. These are very unique circumstances. Not only is the country deeply divided politically, we also find ourselves with a president who faces his own serious problems. Over a dozen cabinet members and senior aides to President Trump have resigned, been fired, or failed their confirmations under clouds of corruption, scandal, and suspicion. The president's personal lawyer, campaign manager, deputy campaign manager, and several campaign advisors have been entangled by indictments, guilty pleas, and criminal convictions. So it's this backdrop that this nominee comes into when what we're looking at is he within the mainstream of American legal opinion, and will he do the right thing by the Constitution? We are also experiencing the vetting process that has cast aside tradition in favor of speed. When Justice Scalia died, Republicans refused to even a meeting in their office with President Obama's nominee, and held the seat open for 1 year. Now, with a Republican in the White House, they've changed their position. The majority rushed into this hearing and is refusing to even look at the nominee's full record. In fact, 93% of the records from Kavanaugh's tenure in the White House as counsel and staff secretary have not been provided to the Senate, and 96% has not been given to the public. We do know what the White House thinks of this nominee. Don McGahn, the White House counsel, spoke to the Federalist Society and made clear Brett Kavanaugh is exactly the kind of nominee the president wanted. In his speech, Mr. McGahn discussed President Trump's 2 lists of potential Supreme Court nominees. One, he said, was filled with mainstream candidates. The other list included candidates that are kind of too hot for prime time, the kind that really would be really hot in the Senate. Probably people who have written a lot. We really get a sense of their views, the kind of people that make people nervous. That's a quote. Now, what I'm saying, this is the backdrop into which we come into this situation. So, yes, there is frustration on this side. We know what happened with the prior nominee, the last one President Obama presented to us. He never even got a meeting. He never got a hearing. He never got a vote. And now the rush to judgment and the inability to really have a civil and positive process ends up being the result. I really regret this, but I think you have to understand the frustration on this side of the aisle. Everyone on this side of the aisle wants to do a good job. They want time to be able to consider what the findings are. And there are tens of thousands of pages of emails and other items which could constitute findings on a whole host of major subjects that this nominee may be faced with. And they're serious. The torture issues, all of the Enron issues that he's been through all of the kinds of things that we want to ask questions about. So, I mean, understand where we're coming from. It's not to create a disruption. It's not to make this a very bad process. It is to say, majority, give us the time to do our work so that we can have a positive and comprehensive hearing on the man who may well be the deciding vote for many of America's futures.
Mr. Chairman, I renew my motion to adjourn and Senator Harris's motion to postpone. I ask for a second.
Second the motion.
Mr. Chairman, I ask for a vote.
Yeah.
I ask that we
I don't know.
reconvene in executive session
I
and have a
shouldn't have
vote.
to explain to you, we're having a hearing. It's out of order. We're not in executive session. That'd be the proper forum for entertaining motions.
I ask that we reconvene in executive session. We
won't vote on Senator Blumenthal's suggestion. We won't follow your suggestion.
Well, it's a motion, Mr. Chairman.
To go into executive session. Motions would not be proper at this time.
Mr. Chairman, it's a pending motion before the committee.
Yeah.
Mr. Chairman, if there is no vote on this motion, which has been properly seconded and which could be given a vote in executive session, this process will be tainted and stained forever. I'm asking as a member of this committee, it's my right to do so, that we vote on my motion to adjourn and Senator Harris's motion to postpone, and that we do it in executive session, which can be easily and quickly convened right now.
Yeah. The motion is out of order.
Sir, then I make a very clear and simple motion to move into executive session so that Senator Blumenthal's motion may be considered.
The motion is out of order.
Well, they're not out of order, Mr. Chairman. They're properly before this committee. Simply saying so, with all due respect, and I have great respect for the chairman, doesn't make them so. It doesn't make them out of order just because the chairman rules that they're out of order. We have a number of excellent lawyers in this room, and I ask that this body now do what its responsibility is, to have an executive session so we can vote on a motion to adjourn, and then we can deliberately and thoughtfully consider the documents that have been presented and also review the committee documents that have been marked confidential without any reason or rationale.
The motion is denied.
Sir, how long would that take? 10 minutes for us to have a motion and a vote on this process? I don't understand what the rush is that we can't even let senators vote on what is a very important motion germane to our constitutional duties before this body, before we proceed. I don't understand. It won't take that much time. What is the rush? What are we afraid of to hold a vote on the motions before us?
Mr. Chairman. Mr. Chairman.
Senator Kennedy.
Thank you, Mr. Chairman. I have a question about the process. I understand my colleague's point, and I understand they feel strongly about this. But what are going to be the ground rules today? Are we going to be allowed to interrupt each other, interrupt a witness? Are we going to, should we seek recognition from the chair? I just want to understand the ground rules.
Proper respect and decorum, plus how we normally have done business in a hearing like this. We wouldn't be having all these motions. You're new to the Senate, so this is something I've never gone through before in 15 Supreme Court nominations that I have been since I've been on here. And every member, I was interrupted before I got a chance to say what the agenda for today, but every member is going to get 10 minutes to make their remarks, and then we will go to the introducers of Judge Kavanaugh. There will be 3 of those. They will take the usual time of introducers, and then we will have the swearing in of Judge Kavanaugh, and then we will have his opening remarks, and then we will adjourn for today. We'll reconvene at 9:30 on Wednesday and Thursday. Each member will have 30 minutes to ask questions or make all these points they're making right now. for the first round. Then there will be a second round of 20 minutes each. So every member is going to get 50 minutes to ask all the questions or make all the statements that they want to make in regard to anything about this candidate or anything about how this meeting's being conducted. And then we will go late into Wednesday night or Thursday night till we get done with the questioning of Judge Kavanaugh. And then on Thursday, we're going to have 3 panels of 6 each, evenly divided for people that think Judge Kavanaugh should be on the Supreme Court and people that think he should not be on the Supreme Court.